Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for argument in our civil number 17-205, PROCACCIANTI versus SHAFFER. Each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. Counsel, but you'll need to keep track of that time for yourself. We've read the briefs in conference this case. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Good morning. May it please the court. I am Bob Porter. I represent the defendant appellant Diana SHAFFER. Arizona law forbids evicting owners of a condominium unit who occupy it. More than summary proceedings are needed to dispossess such a person from her property. Here we have there's an issue here of subject matter jurisdiction. It boils down to that this trial court did not have jurisdiction for the forcible detainer proceedings of ARS section 12-1177. This comes about from a statutory scheme, and the statutory scheme is evidenced in both the exclusions from the Arizona Residential Landlord-Tenant Act in 33-1308, as well as in the definitions of a condominium and a leasehold condominium in Title 33, 1202, etc. Here, and we also have a case precedent, the Cadera case. The exclusion from the Arizona Residential Landlord-Tenant Act excluded owners of a cooperative and the occupants of a condominium unit owned by the occupant in the same exclusion. Cadera involved a cooperative, and there the court examined the arrangement and said that the trial court did not have jurisdiction to summarily dispossess the person who occupied by virtue of an occupancy agreement because of the hybrid property interest.
Yeah, but there was a special statute for cooperatives involved in Cadera.
There is a special statute for cooperatives, as there is a special statute here for condominiums.
Except the arrangement we're talking about is not a condominium arrangement, but a ground lease.
The ground lease is no different than the occupancy agreement in the Cadera. It's a different setup because it's a condominium unit and it's a leasehold condominium. The statutes on condominiums in 1202 recognize this condominium unit and a leasehold condominium, such as we have here. The ground lease here was of the tract of ground on which the condominium sits. And here Diana SHAFFER purchased the improvements, the condominium unit itself. And
is there a statute, though, associated with condominiums that contemplates ground leases?
I think the definition of a leasehold condominium contemplates this type of arrangement, this structure.
Okay, and the specific statute that gives us that definition
is 33-1202. Let me get you this subsection. It's 1202, number 10 for the definition of condominium, and number 16 for the definition of a leasehold condominium. The leasehold condominium definition says it means a condominium in which all or a portion of the real estate is subject to the lease, the expiration or termination of which will terminate the condominium or reduce its size.
Okay. how does that apply here? I don't recall the ground lease saying that the condominium regime would be terminated if the lease expires or if the rent isn't paid.
Well, what the sublease states unequivocally is two things. The sublease says, number one, you own the condominium itself free and clear of this sublease. Mm-hmm. It's not what's being subleased. Number two, it goes on in the sublease recognizes that for purposes of condemnation, the person who has a condominium has a valuable property right, and then goes on to say in the default provision that if there is a default in the ground lease, the ground lessor then has the right to seize and dispossess the owner of the condominium.
Right, but the ground lease, and this is an oddly structured transaction, it seems, because the ground lease, as far as I can tell, isn't part of the condominium regime. The condominium relates to the structure and not the land, which is atypical. But if I'm misunderstanding the nature of the transaction, please tell me.
Well, I will admit, it's an unusual setup, but the setup was made by a declaration, and in that declaration, the landowners, the ground lessors, all agreed that 8 acres on the interior.
Well, aren't the landowners are the ground lessors, right?
They
have
are.
to be, yeah.
Right. And so the ground lessors said to the hotel that we're allowing you to develop those 8 acres for condominiums, and there will be a declaration of horizontal property regime for those condominiums for residential use. And so that necessarily required, because at the time that was done, all the property was subject to a 99-year ground lease at that time. So it had to, and then the hotel then, for each of there's 29 tracts, for each of the people who bought or agreed to sublease, they agreed to have the hotel construct their condominium.
Right.
And then buy it. So it was part and parcel, the transaction here where the sublease was involved was part and parcel of purchasing and having the condominium unit constructed and then purchasing it.
But it's odd because normally in a deal like that you would expect that the condominium association itself would be responsible for maintaining the leased real estate, and here it's not that way.
And again, it fits the definition of condominium, because the condominium definition that I cited says that the owners of the condominium have to have an undivided interest in all of the property. Here they do. Here the homeowners association has no interest in the property, holds no undivided interest or any part.
When we say property, aren't we talking about the property that is defined as the condominium, which here excludes the real estate?
No, what we're talking about here, to continue this unusual structure that was set up by the hotel, the way it works is that all 29 owners have an undivided 29th interest and the exclusive right to get to their condominium.
Sure.
Okay, and so all of them together are responsible for the ground rent.
Well, all of them together are responsible for paying one ground rent payment?
Or
each unit owner is responsible for the rent of the land underlying its property?
By the recorded documents, it's the former, but it's the latter by way of practice. The homeowners association has the hotel bill all of the owners for assessments, garbage, etc., and included in that bill is the ground rent.
Okay. But if an owner doesn't pay the ground rent, as I read the documents, that doesn't mean the other 28 owners somehow have to chip in to make up the difference.
That's correct. They do not.
So, I mean, this is not this is an uncommon structure in Arizona. It doesn't seem to be an uncommon structure in some other states. It's a rather typical way of handling even single-family residences in some states, and the consequences of non-payment of the ground rent are as played out here. Why should we view this as anything other than a literal application of the documents that establish the leasehold?
Because of the policy the legislature set forth in their exclusion from the Arizona Residential Landlord Tenant Act. This is not a commercial lease. This is a residential transaction where the owner purchasing is going to own the condominium and have to pay a ground lease payment. And so that it's unusual, that it's odd, should not deprive such a person of the statutory protections and allow that person to be summarily dispossessed of their rights.
Well, but the statutory protections, as I see it, were designed to protect the usual case. The fact that this deal was structured in an unusual manner does take it out of any statutory definition that might otherwise protect your client, doesn't it?
No, I respectfully disagree. Okay. I think when the legislature said an owner of a condominium unit who occupies it and the owners of cooperatives are excluded from the Landlord Tenant Act, they were not saying if there's going to be some exceptions to this definition. And the Cadera case expressly mentioned owners of condominium units, and it's.
But this isn't the condo saying you didn't pay your condo assessments, and so we're bringing an FED. And that seems to be the statute you're talking about. The protection is against that sort of an eviction.
Well,
right?
The
plaintiff here isn't the condo.
Yeah, I disagree because we're not dealing with homeowners' assessments. The homeowners association has no rights to evict anybody. They don't own any property. They don't have any contractual rights. It's only the hotel and the condominium owner. Strictly speaking, on a condominium, if you're in New York City, you basically own the inside of the walls and the airspace, and that would be considered odd in Arizona. What I'm saying is, when you look at the statutes here, the exclusion, and then when you look at the definition of condominium and look at the definition of leasehold condominium, those set a template that entitled owners who occupy a condominium unit to more than summary proceedings before they're dispossessed. The hotel has a remedy. They have a judgment already from another case. They can execute upon that and take away Ms. Schaefer's rights. Here they tried to summarily do that, and I think Cadera and the statutory scheme expressly prohibits that. If there are no more questions, I'll reserve the rest of my time for rebuttal.
Thank you.
Good morning, Your Honors. My name is Andrew Federhar, and along with Jessica Gale from Spencer Fane, we represent PROCACCIANTI. This case is a little different than the normal real estate case, but that doesn't mean it should have a different outcome than the outcome that happened at the trial court. This is a case that arises out of a tenant to a ground lease, just a ground lease, not a residential lease. The appellant has admitted in her reply brief that this is not under the Arizona Residential Landlord Tenant Act. So this is just a ground lease. So the question is whether, under a commercial lease, a tenant who fails to pay ground rent for a decade is entitled to remain in possession of that property when the landlord asks to evict.
It's a commercial lease.
Because it is not a residential lease, Your Honor.
Well, but that presupposes that a lease must be one of the two. I don't think we can just assume that because an animal isn't a cow, it must be a goat. That we have a lease here that can be read according to its terms. I'm not sure that it matters whether it's commercial or not. The real issue is whether the lease is so interwoven with the condominium that the statutes exempt this type of arrangement from the FED procedures.
And the answer to that, Your Honor, and I'll just jump right to that. The answer to that is found in the sublease itself at page 5. It's in appellant's index of record or appendix. It's at page 89, where it simply says the unit will be owned by the sublessee or buyer, in this case, let's assume Ms. Schaefer, to the terms, according to the terms and conditions, assessments, liens and restrictions in the declaration, and is not part of the estate subleased hereunder.
Okay. So then potentially Ms. Schaefer could hire a truck, a bunch of jacks, and take her condo away.
Well, I think the sublease prohibits that, Your Honor. But in theory, if she was able to overcome the other terms of the sublease that prevented that, you're correct. But she didn't do any of that before the termination of her lease, her sublease, which occurred after giving proper notice and opportunity to cure. And so having been notified of the hotel's intent to evict her, she did not bring herself current. She did not make any payments. She did not do anything to secure the rights and privileges that she might otherwise have in the improvements on the land, and thus allow this forcible entry and detainer action to go forward. So she could have taken other actions. She simply didn't. And so now, Your Honor, you're being asked to take a look again at the Cadera case. That was not an issue that was ever brought up in the proceedings until the commissioner, Commissioner Barth, as he was about to rule, says, you know, in other cases, people have talked to me about Cadera. Does it have any application here? So it was a sua sponte evaluation by the trial judge of whether he had subject matter jurisdiction. Nothing the matter with that. But that's how this issue came up in this case. It was not a defense raised by Ms. Schaefer at all in the proceedings below. So what we have here is a tenant under a lease who's defaulted. The lease is entirely separate from the improvements on the property by the very terms of the lease. The documents themselves do not create an ownership interest, and it can't. The small family trust is the owner, the fee owner of this 20-acre parcel. It leased that to the predecessor in interest of PROCACCIANTI back in the early 1970s, and PROCACCIANTI has now ascended to the position of the sublessee, of the lessee, and they've subleased it to 29 individuals. The condominium approach may affect the improvements on the land, but it has nothing to do with the land itself. The HOA does not pay the ground rent, as Your Honors asked about earlier on in this morning's proceedings. It's the obligation of the individual sublessee of the land. That would be Ms. Schaefer. So for more than a decade, PROCACCIANTI and its predecessors were paying the rent on that land to the small family trust. And once that amount of rent was reduced to a judgment in another case that is pending in front of a different panel of this court, and assessed damages, the hotel moved and asked that she either come current or that we would evict her by terminating her lease. Her non-payment terminated the lease. It's as simple as that. This is not that complicated a case because this is a person who simply thinks she can remain on land that she leases without paying for it, and that the terms of the lease don't apply to her. So unless the court has other questions for me, I think, judging by the questions that we've heard, and I know you've read the briefs, we put forward our position in there, I hope clearly, to the court. Unless you have other questions for us, I don't really have a lot more to say than that. Thank you.
Thank you, Mr. Fenner.
First of all, let me address this decade reference. PROCACCIANTI obtained a judgment in a 2012 case for back rent. In that proceeding, they asked for FED relief, but dismissed that claim when the judgment was entered in that case. So when PROCACCIANTI started out this case, they said much the same thing. But when I pointed this out, PROCACCIANTI changed its tune and said, and the judgment so reflects, that this is only for the rent that was due after the date of that judgment, which was February of 2016. So when we hear these repeated references to decade, it's just to somehow pillory Ms. Schaeffer when PROCACCIANTI had the rights in the 2012 complaint and intentionally did not exercise them. So we're here only about the rent that was due in 2016. And it doesn't matter, but that rent was tendered in these proceedings. It doesn't matter because such a tender is really pursuant to the Residential Landlord-Tenant Act. But just to make clear about this decade of not paying rent, that is the record. The next part is the hotel itself has recognized that these owners of these condominium units have a valuable property right. How? They put a right of first refusal in the sublease, saying if you're going to sell your condominium unit, you have to give us, the hotel, the right of first refusal to purchase that condominium unit. That
I'm not sure how that informs our consideration of this problem, though. Maybe I'm just not connecting the dots. How is the right of first refusal relevant?
because it's in the sublease.
Okay.
And the sublease is where this tract is being leased. So the hotel is taking that arrangement, that ground sublease, and giving itself a position on the ownership of the condominium itself. They are combining the two concepts. They are telling the lessee here, Ms. Schaeffer, in the same breath, they're saying, you're only leasing ground, but we have the right to purchase your condominium.
But you could well imagine a situation where a lessor leases property to a business, and just because it sees it as a business upside, it gives itself a right of first refusal on the business assets if somebody's going to sell the business. I don't think that means the land and the business are connected. That's just an extra advantage for the lessor that's commercially negotiated.
That may well be in that situation, but I think the Arizona legislature wanted to accord special protection to a class of persons who were owners of condominiums and occupied them to prevent summary proceedings against them.
Do you think the legislature ever had in mind this sort of a structure? I've never heard of one before. I have a hard time imagining the legislature took its time to think about what if somebody does a 1 in 1,000 transaction like this.
I'm not Justice Scalia, God rest his soul, or anyone else. I could not divine what the legislature. I've looked at the history. That's just not there.
He would tell you shouldn't even try.
Correct.
And he might be right.
Right.
I was just following your argument.
Right. But my argument is based on the wording of the exclusion from the Landlord-Tenant Act itself and the condominium definitions that are contained in the same title. I think a fair reading of that statute says these class of persons are entitled to special protection so that summary proceedings cannot be exercised against them to dispossess them from their property rights. However those property rights are structured, whether it's a cooperative or whether it's a condominium. And no one could foresee how things would evolve or how complicated it would get or how the structure would be odd. It's just a principle that's laid out with definitions. And I believe that Ms. Schaeffer is entitled to the protection of the law. Thank you. That's all.
Thank you, counsel, for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. We'll be at recess.